Good morning, good afternoon, or good evening. Today's video, we are talking about the Bill of Rights. First, I'm going to give you a little historical background on the Bill of Rights. So, the framers of the Constitution, those who wrote it, did not think that it was necessary to put an explicit Bill of Rights into the Constitution. Why? Because they were working under the assumption that we have limited the government already. The most important step in writing the Constitution was to limit the government. So we don't need to explicitly list every right that people have. In fact, that would limit the amount of rights that people have, because if we put specific rights in the Constitution, then they were unable to be changed. The government would say, well, we only have to protect these rights. We don't have to protect any other rights. And they didn't want the people to be limited that way. And so they wanted to leave a Bill of Rights out of the Constitution. The Anti-Federalists did not like this. Their argument was, if this document is supposed to give us liberty, then why aren't those liberties spelled out? Why aren't those liberties explicitly protected? You want us to sign this document? Spell out our liberties for us. Many delegates from many states wanted a very clearly spelled out list of what their protected freedoms were before they would sign off on it. Problem is, by this point in time of the Anti-Federalists versus the Federalists, several states had already ratified the existing Constitution, and the framers kind of told the Anti-Federalist states, listen, we'll put a Bill of Rights in it after we ratify it. We can't just put a Bill of Rights in, because then we would have to get it re-ratified by all the states that have already ratified it, and they didn't want to do that. So the Anti-Federalists actually ended up ratifying the document without a Bill of Rights, but with a little bit of an IOU, with the promise of, we will put it in, we've allowed for an amendment process, we will use the amendment process to add a Bill of Rights in. And so where did they get the idea of having a Bill of Rights? From the English Bill of Rights, because we plagiarized most of our government, right? Now, the big constitutional question when it comes to the Bill of Rights is, does it apply to the federal government only, or does it apply to the states as well? Is the Bill of Rights a simple guarantee that the federal government won't infringe upon these rights, or is it also a guarantee that the states have to refrain from violating these rights as well? Some people think that the states are not bound to uphold these rights. Some people, like pretty much every Supreme Court in the history of ever, have said that yes, the states still have to uphold these rights. The states can't violate the Bill of Rights, just like the federal government can't. The rights are there for a reason. So let's get into them. The First Amendment, this is what the actual text says. I'm going to show you the actual text of all the amendments. You don't have to write down the actual text. Just write down the explanations that I give you. But I'm getting ahead of myself. Amendment 1 is, Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof, or abridging the freedom of speech, or of the press, or of the right of the people peaceably to assemble and to petition the government for a redress of grievances. This gives us the freedom of religion. Congress cannot establish an official state religion or pass a law that stops people from following their own religion. So we have the Establishment Clause, can't establish a religion. We have the Free Exercise Clause. As long as your religion is perfectly harmless to everyone else around you, you are free to exercise it. We have freedom of speech and freedom of the press in America. Congress cannot stop people from speaking or writing what they wish to a point. There's something called the clear and present danger test, where it says you can't scream fire in a crowded theater if there's no fire, because that would pose a clear and present danger. That would put other people in danger of being trampled as a stampeded their way out the theater. So you can't put other people in danger with your speech or with something you've written. In America, we also have freedom of assembly, meaning that Congress cannot make laws that can stop people from holding peaceful meetings or from asking the government to correct a wrong. Protests are a protected right under the Constitution, so long as they are peaceful. The right of the people to peaceably assemble is protected. The right of the people to riot, Daniel Shays, is not protected. On to the Second Amendment. The Second Amendment states, a well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. The people in the United States have a right to protect themselves by serving as armed citizens in a militia, and Congress cannot stop them. Congress has historically restricted the possession of certain weapons. You can't, as a regular old civilian, own a rocket-propelled grenade launcher. States have also historically regulated the use and sale of guns. However, many of these laws have been struck down in recent years. Chicago used to have a ban on all handguns, but that was struck down by the Supreme Court. This law, this amendment, is written very ambiguously. Is this the right of the people, of every individual, to bear arms? There are a lot of people that think so, yes. Or is this the right of the states to form a militia? A lot of people think that that's what this is saying. It's written very ambiguously, so really it's up to the people to decide, and whatever you decide, vote for the people who stand with you on this issue. That's the way our government works. The Third Amendment, no soldier shall, in time of peace, be quartered in any house without the consent of the owner, nor in time of war, but in a manner to be prescribed by law. This means that you cannot be forced to house a soldier in your home without your consent in peacetime or in wartime. Fourth Amendment, the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrants shall issue but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. This is your protection against being unreasonably taken or your belongings to be unreasonably searched or taken. Your home, the law enforcement officers need both probable cause and a search warrant in order to search your home. Why? Because in your home, you have a reasonable expectation of privacy. That's the legal term for it. You expect your home not to be invaded. You have an expectation that when you are at home, things are private. And so the police, the marshals, the sheriff has to go to a judge, and the judge has to sign off that, yes, this person has probable cause to search your home, and they have to issue a search warrant. And they cannot search your home unless they show you that search warrant. You also have a reasonable expectation of privacy in your phone these days. Your cell phone is afforded a reasonable expectation of privacy, so the police also have to get a warrant to search your cell phone as well. Your car, the police still have to have probable cause. They don't need a warrant because you don't have the same expectation of privacy when you're in your car. And it has to be something that the officer is confident that he or she can prove before a judge. Searching or taking your person, well, before they can take you bodily into custody, they have to have an arrest warrant, or they have to have probable cause that you have committed a crime. All right? Basically, they can't just take someone and they can't take their property without following the law. That's what this protects. Amendment 5. No person shall be held to answer for a capital or otherwise infamous crime unless on a presentment or indictment of a grand jury, except in cases arising in the land of naval forces or in the militia when in actual service in time of war or public danger. Nor shall any person be subject to the same offense to be twice put in jeopardy of life or limb, nor shall be compelled in any criminal case to be a witness against himself, nor be deprived of life, liberty, or property without due process of law, nor shall private property be taken for public use without just compensation. Amendment 5 is a long one. I'll try to kind of rapid fire go through all the parts. Part 1. Before anyone can be tried in federal court for a serious crime, they have the right to put their case before a grand jury. So this is I think it's 12 regular juries put together. The grand jury decides whether or not to indict that person. What that means is that the grand or the really big jury decides whether or not that case goes forward and whether or not that person has to be put on trial in a federal court. Second part is no double jeopardy. once you're convicted of a crime or acquitted, you can't be tried again for that same crime. The opinion of the court stands. You cannot be tried twice for the same crime. However, a state court can try you for the same crime that a federal court has tried you for, and the government is not immune from double jeopardy. The government can be tried for the same crime twice. Self-incrimination. You can plead the fifth. You are not compelled to speak against yourself in court proceedings or in front of law enforcement. If you've ever watched any cop shows, when someone's arrested, first thing they say is, you have the right to remain silent. Anything you say can and will be used against you in a court of law. And then usually they cut out the scene before they can get any further into the rest of your rights. Meaning, you don't have to say anything in front of law enforcement, and you don't have to say anything in court if you know that what you say is going to make you sound suspicious. Next is the due process clause. This is important because you can't be stripped of your life, your liberty, or your property without due process of law, without hearing the charges against you, without a speedy and public trial, without the right to a jury if you are not a minor, so on and so forth. Basically, the government can't take anything away from you unless they go through the proper channels. Eminent domain is the last part of the Fifth Amendment. This is such a long amendment. They should have split it into two, but I didn't write it. It's above my pay grade. Eminent domain states that your private property cannot be taken government's just purpose unless they compensate you for it. If a highway is being built in your backyard, the government can have the land. They just have to pay you for it. Amendment 6. In all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial by an impartial jury of the state and district wherein the crime shall have been committed, which district shall have been previously ascertained by law, and to be informed of the nature and the cause of the accusation, to be confronted with the witnesses against him, to have compulsory process for obtaining witnesses in his favor, and to have the assistance of counsel for his defense. These are the rights of the accused. You must be given a speedy public trial, and, we got a little ahead of ourselves. And you must be given counsel for your defense. You have to be supplied with a lawyer if you can't afford one. Amendment 7. In suits at common law, where the value in controversy shall exceed $20, the right of trial by jury shall be preserved, and no fact tried by a jury shall be otherwise re-examined in any court of the United States than according to the rules of the common law. This is your right to a jury trial in cases involving more than $20, or if both sides of the case agree to forego the jury trial, then you don't have to. Amendment 8. Excessive bail shall not be required, nor excessive fines imposed, nor cruel and unusual punishments inflicted. Courts can't impose an unusually large bail in order to be released pending trial. Courts also cannot impose an excessive fine for a crime. What is an excessive fine? Well, that's a really subjective thing. What's excessive for one person might not be excessive for the other person, and that is why recently, as of 2023, Illinois has actually gotten rid of the cash bail system, because what defines excessive, that's really, really vague. So we'll see where that goes. This also states that you cannot punish convicted criminals in cruel and unusual ways. The definitions of cruel and unusual are very broad, and they have changed a lot over the years. It didn't used to be cruel and unusual to hang someone from a tree until they died. It is now cruel and unusual to do that. It didn't used to be cruel and unusual to behead people via guillotine. Now that is considered cruel and quite unusual. So these definitions are meant to change and update with the times. Amendment 9. The enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people. What this means is that these are not the only rights that people have. These rights don't make other non-listed rights less important. Amendment 9 ensures that this list of enumerated rights doesn't take away any rights that are not listed, like the right to vote or the right to medical freedom. This was kind of the middle ground amendment between the Federalists and the Anti-Federalists This kind of ensured that the rights that the government had to protect wasn't limited to just this list, but it also allowed for a list of specific rights to be added into the Constitution. And finally, the last of the Bill of Rights, Amendment 10. The powers not delegated to the United States by the Constitution, nor prohibited by it to the states, are reserved to the states respectively, or to the people. What this means is any powers not given to the federal government or to the states are not prohibited. In other words, whatever's not in this Constitution is reserved for the states, and anything not given to either the states or the federal government is given to the people. If the federal government doesn't have power over it, and if the state doesn't have power over it, then you have power over it yourself. And that, my friends and neighbors, is the end of the Bill of Rights. We will wrap this up with Amendments 11 through 27 in the next one. For now, have a good day.